Good morning, everyone. This is Monica from the Epilepsy Foundation of Connecticut, and we are in our last webinar for our fall webinar series. And for the purposes of sound quality, everybody has been put in listen-only mode, but we welcome you to use the chat icon on the bottom of your screen to type any questions that you may have. And all of your questions will be answered at the end of the presentation. Our presentation today is titled Protecting Children with Epilepsy, Understanding the Americans with Disabilities Act in Camp and After-School Programs. So we have found that it is not uncommon for parents of children with epilepsy to experience challenges in the area of enrolling their child in a camp or after-school program. These challenges may be related to medication or simply a lack of understanding and information about seizures. Our presenter today will speak further about some of these challenges and what the ADA, or Americans with Disabilities Act, has to say about your child's right to participate in these programs. I would now like to introduce our presenter, Bonnie Roswig, who is the Senior Staff Attorney for the Center for Children's Advocacy, and she specifically works for the program for the Center's Medical Legal Partnership Project. Their office is located in Hartford. Prior to joining the center, Bonnie worked as a legal aid attorney in Georgia and was a supervisory attorney at the statewide legal services in Middletown, Connecticut. Bonnie is an adjunct professor in the legal process program of the UConn School of Law. She is a graduate of Bennington College and Antioch School of Law. And Bonnie will also be talking a little bit more about what it is that she does there at the center. I would now like to hand it over to Bonnie. Thank you.
Thank you so much, Monica. Welcome to today's webinar on legal protections for children with healthcare conditions and specifically with epilepsy. My name is Bonnie Roswig, and as Monica said, I'm an attorney with the Center for Children's Advocacy in Connecticut. The mission of the center is to protect our state's most vulnerable children. I work with our Medical Legal Partnership Project. This includes medical and legal professionals working together with the goal of improving healthcare outcomes for children. Our work includes direct representation of families, training for families and healthcare professionals, and addressing larger issues with the goal of systemic solutions. Children with healthcare conditions can face really a range of issues beyond the need for medical intervention. It's important to view the needs of the child through a holistic lens. There can be a psychological impact of an existing or new diagnosis, social impact of that diagnosis in terms of whether the child is now being treated differently by school, camp, or other programs, and finally, if that in fact is the case, is that treatment legal? So today we are going to focus on the Americans with Disabilities Act. The Americans with Disabilities Act is a federal law which is really an incredibly powerful tool to protect children with epilepsy and in fact all medical conditions. We're going to talk about two sections of the Americans with Disabilities Act, which is commonly referred to as the ADA. One pertains to public sector, and the other pertains to private sectors. In my view, the language of the ADA is truly powerful and provides a strong mandate against discrimination against children with healthcare conditions. So the first section I'm going to talk about is what is known as Title II. Title II refers to municipalities, so programs in cities and towns and schools. And that language is, no qualified individual shall, on the basis of disability, be excluded from participation in or be denied the benefits of the services, programs, or activities of a public entity or be subject to discrimination by any public entity. Title III of the Americans with Disabilities Act is very similar in the nature of its strength and its protections. And that section reads, no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages of any place of public accommodation by any private entity. So who exactly are we referring to when we talk about compliance with the ADA? In the case of Title II, we're talking about programs operated by towns of the state, cities, etc. The ADA makes it very clear that programs operated by municipalities cannot exclude children because of a specific diagnosis. And this certainly includes a prohibition of excluding children because of a diagnosis of epilepsy. Similarly, these programs absolutely cannot exclude children exclusively because they require the administration of medication. Title III of the ADA extends this prohibition to the private sector. So this means that, for example, privately run CAMS, daycare centers, aftercare programs also must provide certain things to children with healthcare conditions. So they cannot exclude a child because of the diagnosis. They cannot exclude a child solely because of the diagnosis of epilepsy. So, for example, no daycare center or camp can reject a child on initial application simply and exclusively because someone puts down on a form that the child has epilepsy. And similarly, they cannot exclude children who require medication. They cannot say, oh, we do not give medication. We do not accept children who need medication. So we're going to look at 3 examples of children with a range of healthcare conditions who may face challenges in getting into programs, daycare centers, or other programs. So, for example, let's look at a child, let's look at Amy. Amy is 7. She has a recent diagnosis of epilepsy, except really during the course of her day, no medication administration is required. She does have a healthcare plan from her doctor, which does include emergency planning if it is necessary, but in fact, she has no recent history of seizures. Our next child is one with so this is Martin. He has very funny. He goes to his main regular classroom and he interacts well socially with children and adults and is very successful in a regular education setting. But our third case is Edward. Edward is 8. He's nonverbal. He has an unspecified genetic disorder and he attends a private therapeutic school. But even in that very structured setting, he has a number of challenges. He still needs a one-on-one paraprofessional. He exhibits aggressive behaviors, and controlling those behaviors and assisting him remains a challenge, even in a very highly structured setting. Really, what the ADA is about inclusion. Children, the assumption is that children with healthcare conditions, including epilepsy, should be included. The ADA actually provides a specific roadmap for facilitating inclusion of children with disabilities and sets out a process for those who seek to exclude children and directs them to really actively try to include. So what does the ADA require? A fundamental intent of the ADA is what is known as a reasonable modification to policies, practices, and procedures. The objective of this, what we call reasonable modification standard, is to avoid denial of access to programs and services for children with disabilities, including epilepsy. The ADA sets out a specific standard to integrate children, parents, and guardians with disabilities. And by the way, it's important to note that the inclusion mandate also applies to parents. So if you have a parent with a disability, the entity, the camp, the daycare center, the town program must also provide an accommodation to the parent so that they can have meaningful participation in their child's activities. It's also key for all parties concerned to understand that the necessary accommodation is a responsibility of the program. Programs cannot require parents to provide medical oversight. They cannot insist that parents oversee medication. They cannot insist that parents physically stay on site with the child, and they cannot insist that parents pay for the staff to be trained so that the child's needs can be addressed. All these things are the responsibility of the entity itself. The burden is not on the parents. So how is a reasonable modification accomplished? This is actually accomplished by an individualized assessment of the child's needs. People can have categories of healthcare conditions, but everyone is an individual, and therefore their individual symptoms and how the diagnosis affects them is unique. So the healthcare condition itself is unique to the child, the impact is unique to the child, and what the child's needs are. So in other words, the necessary modification are based on the child's specific needs. We figure out what that accommodation needs to be by doing what's called an individualized assessment. And that is really exactly what it means. These are analyses of what are the child's needs, what do they need in order to be successful in the program. The assumption is inclusion, the assumption is participation. So what does the camp, the daycare, the school, etc. need to do to make this happen? So in doing this individualized assessment, the entity is required to get information from all those people who are involved in the child's life. So the parent, the educators, the caregivers, and the healthcare professionals. So all of whom can get important information as to how can we make it so this child can be part of this program. And incidentally, administration of medication is absolutely considered to be a reasonable accommodation. It is not appropriate, and I would certainly argue a violation of the ADA or any program to say that we do not administer medication in our program. We do not accept children who need medication in our program just as a blanket denial. That's not all right. Necessary medications, again, as everyone has experience, are generally part of a medical plan developed by the healthcare providers. It is appropriate to assume that camp or daycare staff will be trained in the administration of this medication. And even if it means, again, specialized training, and this training has to be paid for by the entity, the camp, the daycare center, and not by the parents. And in fact, the state of Connecticut Office of Early Childhood provides very specific guidance on this issue, and we'll discuss this a little later in our presentation. So one of our concerns today, obviously, is treatment of children with epilepsy. And as everyone has probably experienced, unfortunately, discrimination against children with epilepsy certainly exists. So the relevant question is, why is this? Why this discrimination? Why does people think that it's okay? And I think that there are a variety of reasons, none of which are acceptable. The first one, I believe, is ignorance about the medical condition. People hear the word, they don't understand it. They don't know the background, they don't have any knowledge, they haven't done any research. They just assume that for whatever reason, they don't have the ability to care for a child with a diagnosis, even when the child needs no additional health care services during the course of their time at the program, even if the child has been symptom-free for a long time. They just don't understand, it's afraid of the horribles, and they'd rather not be involved. The other factor is that there is a lack of knowledge about the Americans with Disabilities Act. We're not saying here that everyone needs to be a lawyer, but they operate within the confines of the United States and the state of Connecticut, all of whom have specific requirements around compliance with the Americans with Disabilities Act. So it is a really fundamental ignorance that this kind of discrimination can go on. And then finally, there is a certain ignorance about liability. There is the commonly stated, thought process of, oh my goodness, something's going to happen, I'm going to be sued. Again and again, we find that this is not the case. The liability comes in when these entities fail to comply with the Americans with Disabilities Act, and then there are monetary sanctions imposed. But again, we'll get to that a little later in the presentation. So what are the accommodations that should be considered when we are looking about accommodations for a child with epilepsy? These accommodations categorically should be no different than accommodations for children with any other healthcare condition. As I said a little earlier, participation absolutely cannot be denied exclusively based on a diagnosis. So again, no entity should be able to reject an application if you say that the child has epilepsy. That should not be the end of an application. If an entity is concerned about acceptance and their ability to meet the child's need, then that individualized assessment must be conducted and information should be obtained from all the relevant players. It just can't be an internal discussion among the daycare center staff of whether we can assist this child or not. All the parties involved should sit down, information should be gathered, and the conversation should be, how can we include this child? How can this child participate in order for the child to get what they deserve and for the entity to comply with the ADA? And in terms of epilepsy, emergency treatment is certainly considered to be a reasonable accommodation by many child care facilities. I think people have had lots of experience that those that won't, but in Connecticut there are a range of child care facilities that will. So if it is a reasonable accommodation for many, it's really hard for the few to argue that they can't do it, that this is an unreasonable request by the family. We're very lucky in Connecticut that we have very specific requirements that govern many child care facilities, camps, daycares, etc. And these are entities that are licensed by the Connecticut Office of Early Childhood. The Office of Early Childhood has very specific mandates for their licensees. There's a long laundry list, but the short relevant ones are every center must have at least one staff member who has completed a 6-hour first aid course. And they recommend that they have more than one person, obviously, if the staff person is going to be out for whatever reason. And this training must include recognition and management of, and the language is emergency conditions, including seizures. So I think that's a real directive, and certainly a violation if entities say, oh, we are never going to do anything about managing a child who has seizures. The Office of Early Childhood has really been very supportive of families and proactively directs their licensees to comply with the Americans with Disabilities Act. In the context of diabetes, and for every entity that they license, they include the form before you. It talks about the specific instance of children with diabetes and the requirement to administer insulin, including injectable insulin. And it also talks about the financial cost of violating the ADA. And we'll talk about specifics in a little bit, but it's important to note that the Office of Early Childhood recognizes, understands, and supports that their licensees comply with the ADA. We've talked a lot about the ADA mandate of inclusion, but there are certain limited exceptions to that mandate, none of which really have to do with epilepsy in my opinion, but I want to walk you through them because I think it's important to know. So there are 3 limited exceptions, and they are what's known as fundamental alteration of the program, undue burden, or direct threat to health and safety of others. The fundamental alteration requirement is really about the nature of the program being offered. Entities are not required to abandon their fundamental mission. So, for example, a camp that is exclusively a football tackle camp. There's a child who is interested, who is a quadriplegic, and cannot be involved in contact sports, obviously has mobility challenges, and really can't function in an aggressive environment. It is appropriate for the camp to say, this child is not an appropriate camper in our program because it would mean a fundamental alteration to our program. Of course, there are broader sports programs, all of whom arguably should have modified sports programs, but in the case of these very narrow, limited programs, fundamental alteration of the basic intent of the program is not required. The second exception is undue burden, which we hear a lot about. Facilities will argue, oh, we couldn't possibly take this child or train our staff because it is too expensive. This is an argument that is an uphill battle for any entity to claim in terms of training, the cost of training, the cost of perhaps even an extra half-time staff person is, under the ADA, is rarely considered an insurmountable burden, and a very close evaluation is done of the program that says they cannot afford the necessary requirements. And when that evaluation happens, there's going to be close scrutiny of the nature and the cost of the accommodation. So, for example, in the context of diabetes training and training on insulin administration, it's basically a nurse coming to the camp and it costs about $150. It's very hard for a national chain to argue that they don't have the money to pay for this individual to come and train. So they look at the entire budget of the camp. They also look at the financial resources of the parent company, be it statewide or national. The number of employees, whether it's really totally impossible, and the impact of this accommodation on the entire operation. So really, when an entity claims undue burden, they can't afford it, they don't have the time, they don't have the staff, when the Justice Department comes in and evaluates that claim, they are making the company open up their books, going through every page, and it is a very difficult process and an uphill battle for the entity to successfully claim undue burden. The final exception is direct threat to health and safety of others. So we talked about the little boy with Down syndrome. I'm sorry, the little boy who had a genetic disorder. He was in a private therapeutic school. He had aggressive behaviors. Really what we're looking at is whether or not it is safe for the child, for the other children, for staff, for the child to participate. Ultimately, there are going to be times when children like Edward will not be able to participate in the program unless it has the intensive supports internally to keep him safe. So finally, I'd like to talk about some cases that we've brought recently that have had very positive results for children with a range of disabilities. One of our most recent cases was we filed a complaint against KinderCare. KinderCare was refusing to provide insulin injections to children with diabetes. Children either could not attend at all or could only attend if their parents left work or left home and came on site to provide the treatment. I filed a complaint with the Justice Department. The Justice Department opened an investigation, and as a result, KinderCare now must provide insulin, including injectable insulin, to their campers who need it, develop policies around diabetes oversight, and train staff, all at the expense of KinderCare. This, even though the case was filed in Connecticut, this applies not only to the Connecticut locations, but to their 1,800 locations nationally. Not only that, but KinderCare had to pay $24,000 to the three main families who were named in the original complaint, so $8,000 to each of those families. And also there was press around the settlement agreement. The next case was, again, a case, discrimination case against a child with disabilities. Only this one was filed under the Fair Housing Act with the Department of Housing and Urban Development. In this case, a special education student who required door-to-door transportation as part of his school programming. The condo complex that he lived in forbid the vehicle from coming onto their property. The condo complex would not agree to change their practices. I filed a complaint with the Department of Housing and Urban Development, and as a result, the bus is now allowed on the premises. An individual letter had to go out to all tenants regarding the obligation of the condo complex to accommodate to children with disabilities. They had to post notice in their public areas regarding their duty to accommodate, and all condo staff had to be trained at the expense of the condo management company. And not only that, but again, continuing oversight by Housing and Urban Development, and again, these entities are not happy when someone is looking, when the federal government is looking over their shoulder to ensure that they are complying with the ADA. The ADA also applies to a range of children with disabilities, including children with mobility issues. Because of this, the ADA actually has architectural standards that address access for children with mobility issues. So a little girl named Sasha could not access the town school playground because she had cerebral palsy. The school and the town were not responsive to requests for accommodations or to change things so that Sasha could play with her peers. As a result, I filed a complaint with the Justice Department, and a settlement agreement was entered. The Justice Department attorneys were involved, as well as a Justice Department architect. Now, the town and the school have to pay $200,000 for the appropriate playground upgrades. They will have continuing oversight by the Justice Department, and this case really got national press. This case went around the country. It was picked up by the Associated Press, and it now, as really all these cases, create a standard of accountability for entities to comply with the Americans with Disabilities Act. And if you would like to see an inspiring YouTube video by a parent, please click on the link. Sasha's mom is a wonderful advocate, as I'm sure you all are for your children, and she talks about have heart, keep going. You know, successes will happen even though it is all very difficult. So the last complaint that I filed, and is currently, as we call, pending with the Justice Department, involves a child with epilepsy. Briefly, the facts are that after a daycare center agreed to administer Diastat for a year, when it became necessary to refill the prescription, the daycare center refused to agree to continue to administer Diastat. And of course, this happened 2 weeks prior to the prescription had to be renewed. The daycare center would not administer Diastat, and as we talked about before, did not do any of the requirements that are required by the Americans with Disabilities Act. They did not do an individualized assessment. They did not offer reasonable accommodations so that the child could continue to participate. And so a complaint is now pending with the Justice Department. I don't know how that will come out. We are hoping for the best. For whatever reason, for those issues of lack of information about epilepsy, sometimes this is more complicated, but we are hoping for the best because everyone that understands about epilepsy understands that accommodating a child with epilepsy, even administration of Diastat in an emergency situation is just a reasonable accommodation and appropriate and not such a big deal. So finally, I want to talk just a little bit about the refusal of entities to comply with the ADA. It has a huge negative impact on a facility which they really do not want to see happen. Legal actions are filed, the Justice Department investigates, there are fees for these facilities in terms of their attorneys trying to defend them, there are monetary sanctions, and you go back to the document from the Office of Early Childhood around what those other sanctions came out to be, in addition to the ones that we talked about with KinderCare. And there's a lot of bad press. And no one likes to see their entity which written up badly in the Hartford Courant or in national newspapers. So my thanks to the Epilepsy Foundation for inviting me today to present to you. I am happy to talk to any parents who are having issues or have questions or feel that their children have been treated appropriately. My contact information is on the slide. And thank you so much for participating in this webinar.
Okay, well, thank you, Bonnie.
we will take a few minutes now. If anyone has questions, as I mentioned at the beginning of the webinar, just type them at the bottom in the chat section, and we'll go ahead and answer those. You can certainly email Bonnie directly, as you see her email and phone number on the screen now. So we'll give you a few minutes to do that. And in the meantime, I do have a question, Bonnie. Are there any businesses that would not fall under the Title II and III of the ADA in these situations where they wouldn't be required to accommodate?
I would say that it is very limited. The only sort of blanket exception from the ADA are entities with religious affiliations. However, that being said, if, for example, a church leases out their classroom space to a private child care center, then even though the religious entity doesn't have to comply with the ADA, the private daycare center does. So they don't fit under that blanket exception. But most facilities, at least they have to start the process of compliance. The assumption, step one, is inclusion. If they have concerns, then we go to that process of the individualized assessment and talking about how to accommodate and whether or not that can be done.
Okay, thank you. I think that clears things up, because oftentimes we view those more private companies and businesses and think that they don't fall under this category, but I think that clears.
Title III, it is a common sort of conclusion that sort of private daycare or private camp or whatever doesn't have to comply with the ADA where the town camp does, and that's just not true. Both public and private entities have to comply with the ADA.
Okay, thank you. So if anybody, please, if any parent listening to this has any questions or concerns, this is a lot to understand. The ADA is not exactly simple, as Bonnie mentioned earlier. Not everyone's expected to be a lawyer, but we ought to know the basics to be able to understand your child's rights in these situations. So reach out to Bonnie. Please let us know here at the Epilepsy Foundation of Connecticut if any institution where your child is participating in a program, if they are in need of any training about epilepsy or seizures, or even help getting trained for the administration of the epilepsy emergency medication. Let us know, we can help. Our services are all free, so please let us know if that's something that we can help you out with. And this webinar has been recorded and it will be available on our website at epilepsyct.com for future reference. And if there are no further questions, I would like to thank everyone and on behalf of the staff of the Epilepsy Foundation of Connecticut for joining us and for viewing this presentation. Thank you. And thank you, Bonnie.
Thank you.